Hi, this is Steve Carlson with part 3 of my election contest against Al Franken, who has been declared the winner from the Minnesota contest for U.S. Senate, which would return him there. But a very curious election, just record low turnout. Here's an entertainer. He apparently did not capture the interest. He only got 25% of eligible Minnesota voters to vote for him. So I'm contesting that, and also the result, which by marring my free and fair election, which drove my numbers below the 5%, which would have carried the Independence Party forward to the next election. Not that I would be satisfied with this, and as I argue in this contest, let me add Al Franken in a contest. Of course, he would never allow that. Talking about a debate, a contested debate, or an elections contest where he plays fairly instead of controlling all the money. Here's a man who says that he's so sure that Citizens United was wrongly decided that he wants to basically cripple the First Amendment so people cannot declare or cannot contribute money. At the same time, he wants to keep the emails of voters out. His party wants to keep the emails of voters out of the elections. So if you want to submit your voter email address to the Secretary of State, he cannot make that available to me as a candidate so that I can talk with you directly about my positions and hear your concerns. This could be done throughout the whole state. And it could be across parties, across positions, and you could get things directly from the candidates. Now, wouldn't that be better than being reliant on debates which exclude candidates, or reliant on TV stations which basically just editorialize and present talking heads and think that their voters aren't smart enough to be interested in more than a few issues, which are usually he said, she said, or mudslinging and all the rest, or 30-second sound bites. So Al is against democracy. And this contest is in favor of maintaining a third party, which has a strong structural protections in the Minnesota law, which are now being taken away because of Al Franken and Mark Ritchie. So this is part 3, and so I'm going to continue on. In the first part, the last part, I presented the 4 grounds that spell out the irregularities and serious material deliberate violations of Minnesota election law, which are the basis for this contest, to declare that Al Franken's election is invalid. It's not invalid, and according to Minnesota law, who knows what the Senate will do, but according to Minnesota law, you cannot sit unless you do so by virtue of having won a valid election. And that's from a case from, I think, 1914 called Sari, S-A-A-R-I, which is really a big legal precedent in Minnesota election law and has been updated as recently as a 1978 case, I believe, Pavlak versus Groh, in which the Supreme Court affirmed that. And so if this election is an invalid election, we're faced with a lot of choices. But on the flip side is if we can solve these issues to protect the First Amendment from Al Franken and his party and take the quotas out of DFL endorsements, which get people directly on the general election with a little basically pro forma primary, because who's going to win the DFL primary once they've got this whole gang together that's kind of limited the potential for people to get endorsed. Then I think we can get back on track. We can get Minnesota back on track. We can get elections back on track. So much is said around the Minnesota appellate courts, including the Supreme Court, that judges have made a unilateral decision to limit the jurisdiction of petitions to ballot issues, quote unquote. Who gave these judges this right to ignore the law and their legal duties? They don't have it. They put themselves not only above the law, but above our very democracy. They stifle First Amendment rights. They ignore the requirements of elections. They themselves get elected, and this corruption aids them and serves them well in the pursuit of their own institutional and personal goals. No different than any other tyranny. It announces to wrongdoers, like the DFL and Franken and Ritchie, that they can get away with anything, only just not ballot tampering that gets caught. I contest this, and the Senate and U.S. Supreme Court must protect democracy in Minnesota if we are to have a future as a free and open society, and not be run by cynical manipulators of legal codes reaching in high-handedly during critical decisions to pollute the outcome. These elections are to be decided by the voters, being fully informed and not shielded from the candidates so that they even wonder who the candidates are, or even if they exist. Those charged with wrongdoing in this contest have in effect politically disappeared a Senate candidate and appear very pleased indeed with themselves. Further, for congressional elections, that is to say, either House of Representatives or Senate of the United States, because of Sections 2 and 3 of Article 1 of the Constitution, no Minnesota court has jurisdiction to void any election, the houses of the Congress being the sole judge of their membership and their qualifications. And no court is allowed even to reach findings and conclusions of law on matters of serious, deliberate, and material violations or irregularities in a congressional election contest, although they may do so for state offices. Thus, this Ramsey County Court and the Minnesota Supreme Court, who will select judges to take evidence on the points in this contest with respect to why the declared election of Senator Franken is not valid, may not, but impermissibly did in 2012, make findings and conclusions of law. And in 2012, they refused to accept a timely filed contest against the election of Betty McCollum. The Minnesota Supreme Court did so. They violated this when they failed in their duty to make sure that that contest that I timely filed was followed up by a trial and the results passed on to the presiding officer of the U.S. House. These jurists are unashamed that they usurped the power of Congress given to them by the United States Constitution. They decided that no contest was filed against Betty McCollum, and this finding of fact and law was false and unconstitutional and outside their authority. Despite the clarity of the law in 2012 and again in 2014, Minnesota courts have interposed themselves against the Constitution. In 2012, against said evidence reaching the United States Congress. And this is a real violation of the U.S. Constitution and is highly improper. In 2014, the Minnesota Supreme Court, presented with allegations that the Franken campaign and the Secretary of State were at it again refused to carry out their responsibilities, purporting to chastise me about res judicata and laches, equitable remedies that are not properly used in determining the conduct of elections. It's not anywhere in the code that is prescribed by the Minnesota legislature. Again, the U.S. Constitution, to the judges, your boss, instructs the Minnesota legislature to prescribe, to fix, establish, determine in advance exactly in what manner the election shall be held for Congress, including judicial roles of enforcing those laws. There's nothing there about a clerk popping up and collecting $350 just to carry out the court's election duties prescribed in Chapter 209. There's no determination for a few Supreme Court judges to decide what they want to do and what they don't want to do among their prescribed legal requirements, or to theorize that carrying out specific duties in election laws may or may not be election duties, as they did in 2012, just because they're in the election code. They may not substitute equitable theories like res judicata and laches for the election laws and their clear statutes of limitations. This is serious resistance to the U.S. Constitution in Minnesota. It is the Wild West of election laws, something I had never even dreamed of growing up here. I believe we lived in a democracy because there are free and fair elections, and the laws are enforced. No one would certainly ever bully people not to bring election litigation, not to run, or not to appear. Voters and candidates do not wait to be invited by their supposedly social betters because they own the mass media or can buy them in a democracy. This has evolved. It's evolved now into a corrupt aristocracy, and democracy does not exist and must be restored. This conduct contested here is not only ultra vires, beyond their authority, but it violates our most fundamental law. This law is far above the head of a Minnesota Supreme Court member, or a governor, or a senator. That is why the framers commanded the states to establish election laws to ensure the freedom and purity of the election and of the vote. What this means is very clear. So far as the general election, I, as a legitimate elected nominee to face Senator Franken and Mike McFadden to make this election valid, needed to have had an equal opportunity to be heard and seen by the voters, outside of paid media like 30-second sound bites making claims about Franken's and McFadden's supposed records and abilities. Further, a whole string of U.S. Supreme Court cases, including Buckley versus Vallejo, 1976, Anderson versus Celebrezze, 1983, Tosjian versus Republican Party of Connecticut, 1986, and Eel versus San Francisco County Democratic Central Committee from 1989, have barred those with duties and roles in a campaign from even imposing an unreasonable burden on the rights of the candidates themselves, referring to Buckley and Anderson, and the parties and their candidates in Tosjian and Eel Funk, dealing with the Republicans going against the Democrats. Now, thus, when the state's courts announce they will not allow proceedings by an individual and IP candidate as provided by Minnesota election law to allow a remedy to allegations regarding irregularities or serious, deliberate, and material violations of election law regarding individuals charged with duties related to an election to be corrected or elections set aside, or in this case to be brought before Congress, that imposes an unreasonable burden on that IP party and on its nominee, and thus a violation of both the rights of political expression and of association secured by the First Amendment during elections. In other words, if you're not allowed to have access to the courts during elections or to enforce election laws, then that's a burden on your party. In other words, if a Democrat did it or a Republican did it, they can file these. Well, they have a lot more money and they got attorneys, the whole legal establishment trying to control the outcome of elections. But it's still a serious burden on an IP party when it's in the law that that law is not even going to be followed. And this cannot be justified by the state by saying the Minnesota Supreme Court has not considered those kinds of issues before, or the statute is not a broad vehicle, or that the judges would rather look at equitable arguments than follow the plain law and discharge their duties regarding elections. Nor may the Minnesota courts make the decision for the Congress that is reserved by the Constitution. Again, obviously, when you are excluded, and in this case it was just rumored, no one informed me, so I would have due process, from a publicly broadcast debates because Franken, McFadden, and other organizers decided some time ago that they would not include your major party, that is an unreasonable burden on that major party. And I think that Nathan Hartshorn of the Attorney General's office still is not clear on this, but it is, and I will respond more fully to his answer in a subsequent video. But it is an unreasonable burden if your party is excluded just because of your party identification, which is what they did. The Minnesota Supreme Court decided to let 2 more debates go on without question, without the Independence Party candidate. And that is an unreasonable burden the state must justify and has not, especially in light of their clear regulations of campaign electioneering communications, which is expressed in the Fair Practices, Corrupt Practices Act. And in that section, subdivision 3 of 211B.05, It said compensation prohibited except for paid advertisement. An owner, publisher, editor, reporter, agent, broadcaster, or employee of a newspaper, periodical, magazine, radio, or television broadcast station may not directly or indirectly solicit, receive, or accept a payment, promise, or compensation, nor may a person pay or promise to pay, or in any manner compensate, an owner, publisher, editor, reporter, agent, broadcaster, or employee directly or indirectly for influencing or attempting to influence voting at a general election through printed material in a newspaper or periodical or radio, television, or cable broadcast, except as a paid advertisement as provided in this section. And they have to say it's paid advertisement. So there's no doubt that all the broadcasters were paid for their debate programs. They all had jobs. Clearly, the broadcasters, My9 TV, KBJR, WCCO, CBS Television, and NPR all intended to influence or attempt to influence voting at the general election through material broadcast by radio or television or cable broadcast. They intended to conspire with Franken and McFadden to eliminate all Independence Party candidates. This is outside their own First Amendment rights or editorial discretion as broadcasters, because my own First Amendment rights and those of my major party were unreasonably burdened. And this violates the First Amendment according to a string of U.S. Supreme Court cases. This is so because the debates are to feature my views, positions, arguments, and qualifications, including party, and not the views or prejudices of the broadcast companies who are making money on this. I mean, this was a record election year for spending. That means paying these broadcasters, paying these newspapers. They live on this. With the internet taking away a lot of business, advertising business, they need this to survive. And they should not have this much money coming in. This is hyped. Most of this should be on the internet, and voters should be able to get access easily to the views, qualifications of the actual people on the ballot, candidates on the ballot. The Secretary of State provides some of this, but it's very limited. It should not be so limited. And what they're doing is hyping and pumping up the profits of those who make their money through elections. That is the mass media. So, as I was saying, the Franken and McFadden campaigns gave the media millions of dollars to air their sound bites. And these media were the ones Franken agreed to give the debates to. And if you want to call them debates, a show debate between Franken and McFadden, and to allow Mike McFadden to appear next to the DFL star. So there was collusion to violate the law and Constitution by Al Franken and his DFL campaign. My complaint, which I brought ultimately to the Supreme Court, had gone through the FCC and received a disposition. It was brought to the Minnesota Supreme Court to seek their aid in opening up the elections. Finally, a motion was filed with the U.S. Supreme Court to allow me to participate. However, inexplicably, it didn't get to the justice in time, and the claims were the First Amendment and equal time provisions and the due process implications of electing people empowered to bind all of us with laws with legal effect, that is, determining our substantive rights through elections that are invalid. The equal time provision, 47 U.S.C. 315A, and its implementing federal regulations still require that broadcasters are not required to permit their broadcast facility and license to be used by any political campaigns like Al Franken's or Mike McFadden's, but if they do, they must extend the same opportunity to all legally qualified candidates. Certainly to the other third major party candidate in Minnesota. In this case, there is no legal distinction between myself and Senator Al Franken and Mike McFadden, since we are all major party nominees, because each of us has won the statewide Party primary held August 12, 2014 by our respective parties. Thus, when Franken cut a deal to just feature himself next to the political novice Mike McFadden, he illegally, violating the U.S. Constitution, First Amendment, and equal time provisions, violated the Minnesota election laws that make a small major party equal in legal rights to the big national party. He violated the letter and the spirit, the purpose of this election statute. Further, based on Minnesota Supreme Court precedents on fundamental elections laws in Minnesota, the Minnesota Supreme Court and lower courts simply cannot escape their duty to remedy wrongful conduct by anyone charged, that is, having, under prescription of the legislature, any duty concerning an election. A district court or the Minnesota Supreme Court cannot inform someone uncounseled, pro se, member of a major party that they don't want to make the election fair and valid. This violates the fundamental rights on which our government itself functions. So far as elections, their role is one role only, the court's role, to give effect to the requirements that the elections be conducted in a manner established by the legislature in the election law conforming to the United States Constitution in full and the Minnesota Constitution. And they have not, and apparently continue to refuse because of their great power, that is to say that they may not be made accountable by the people for the powers entrusted to them and the spirit and letter of the law. That they violate Minnesota election law when they fail to regulate the election is absolutely plain and clear from Sari versus Gleason, S-A-A-R-I. And this is from 1914, Minnesota Supreme Court, in which our courts made very clear the role of the courts. That court, the Minnesota Supreme Court, made very clear the role of regulation of election campaigns like Franken's, and that would include the conduct of elections officers like Ritchie. The fact that this state must enforce rules of free and fair elections derives from the precedents of the Minnesota Supreme Court, as well as the U.S. Constitution. Beginning with Sari, the Minnesota Supreme Court first approved the legislative regulation of election campaigns through the then entitled Corrupt Practices Act, cited in Pavlak versus Groh, also Minnesota Supreme Court from 1979. And Pavlak noted, the Pavlak Court, with approval, that the provision of the Corrupt Practices Act, quote, are justified by a necessary extension of the legislature's acknowledged power to regulate the conduct of election campaigns expressed in the Fair Campaign Practices Act itself, unquote. The Pavlak Court also noted with approval that the court in Sari logically and emphatically ruled that the power to promote fair elections necessarily implies the power to set aside unfair elections. Italics added, of course, for this race that could only be done by the Congress. However, the Minnesota courts or the Senate or U.S. Supreme Court could restore the IP status based on this contest. Of what use would it be, said the court, to assess a misdemeanor penalty against Al Franken, against the offender of an election law, while allowing him to hold the office obtained in part by his very violation? An offender or offender party may not reap the benefit of his wrong, and unfair elections must therefore be set aside. It is a recognition of the oldest requirement for democratic office of all, that the candidate must have prevailed in a valid election. If he has done so, he may not sit, unquote. This is from the Minnesota Supreme Court. And that's the law. And yet, Franken is getting a lot of cooperation from the justices that are selected by the Democrat and Republican governors to stifle the rights and ultimately destroy the Independence Party and an independent voters movement that it represents. Now, both McCollum in 2012 and now Franken in 2014, by being declared the winner and successfully destroying the IP through the results of an invalid election he engineered, are reaping the benefit of their wrongs. they are sitting and expect to sit where Franken has not prevailed in a valid election. The Sari and Pavlak courts did not cite the legislature or even the U.S. Constitution. They cited, quote, the oldest requirement for democratic office of all. In other words, fundamental law, fundamental rights that Franken and the Minnesota Supreme Court violated and created great irregularity. This failure has in great part accounted for the demise, challenged here, of the Independence Party and for the travesty of a Senate election, completed with staged, carefully scripted Senate debates, but also in their undemocratic practices. Manner of election of U.S. Senator prescribed by Minnesota election law. 204B.03 Manner of nomination. Candidates of a major political party for any partisan office except presidential elector shall apply for a place on the primary ballot by filing an affidavit of candidacy as provided in the law, and except as otherwise provided in section 204D.03 shall be nominated by the primary. Candidates for any partisan office who do not seek the nomination of a major political party shall be nominated by nominating petition. So I did seek the nomination, but not the endorsement of the IP party, and I did secure it. That's how you get on the ballot. We all got on the ballot the same way, Franken and McFadden and myself. And that needs to be respected and not voided by the courts, and shouldn't be able to be toyed with by media types like Al Franken. What contestees Al Franken and the Minnesota Supreme Court have tried to do is to void my nomination for U.S. Senate by pretending it was not worthy of being honored by debating the winner, merely because the IP is a minor party. It's a minor major party. But this violates the scheme of the election law, which is not that the three parties should be even roughly equal in size. The fact that I'm polling 3 or 4% and under 10% during the general election is to be expected when we only need 5% to be a major party. Therefore, polls under 10% cannot be used under Minnesota election law to exclude the major party from election debates, any more than it can be used to exclude them from the ballot, or exclude them from the statute defining major parties supra, or protect them from judicial protection of their rights. This is determined in advance by the legislature. To exclude the IP violates the action of the Minnesota legislature and the will of the voters, giving them IP status. Perhaps they might lawfully be excluded in some other state where the candidates can be characterized by opponents as fringe, minor, unsuccessful, etc. But not here, because of the very specific election scheme set up in advance, prescribed, which must be followed. To attribute these characteristics to an individual simply for seeking the nomination of such a party is to plainly violate the Minnesota election scheme. If Al Franken or Mike McFadden had joined the IP, they would be equally expected to poll in this single-digit range, because that's what the party is, especially if they weren't allowed to debate. But Al joined the DFL because he has no problem with gender quotas, race quotas, or sexual practices quotas, and so he inherits a larger base. But this does not give him the right to exclude other major parties or start name-calling instead of debating. The argument made by CBS for excluding me from the WCCO-CBS debate in the major arena and to conduct the debate as if I didn't exist had been disappeared as a candidate, as if I was disappeared, went far beyond what they did to IP in 2002 with James Moore. So in other words, this has already come up in 2002 in a case with NPR all of a sudden decided to pull the IP candidate because of the death of Paul Wellstone. They wanted Walter Mondale to step in and get full billing without any distractions to go up against Norm Coleman. And Norm won that, and then Al came and got back at the Republicans and Rush Limbaugh and all that. Now, in that case, however, they didn't go this far. They didn't exclude anybody from a whole season of debates. And with those special circumstances, the tragic circumstances of the death of Paul Wellstone, that was the excuse that NPR used to exclude James Moore from one debate. And they cited a U.S. Supreme Court case, which is CBS versus Democratic National Committee, 1973. And that case found that there was a delicate balance that the FCC had to carry out to ensure the agency did not completely take over the debate and elections conduct. But delicate balance was foreign to the two national parties this time, and when they sought to eliminate a third major party. Their goal was to create imbalance and violate the constitutional rights of another vulnerable major Minnesota party and clear the field for future elections, which they're touting on TV now, so they could pursue a two-party election strategy instead of a three-party election strategy. This cycle, instead of pursuing a legitimate three-party strategy, in other words, they actually pursued a futuristic two-party strategy. That is to simply ignore and trample the rights of the third major party and their nominees. Now, CBS versus DNC held that the FCC, quote, is charged with the duty of fairly and impartially informing the public audience, unquote. Now, clearly, if the FCC did this, fairness would have required being informed of the positions, arguments, and qualifications of the duly elected nominee of the third major party in this race. That same case continued, quote, the initial responsibility for fairness, balance, and objectivity lies with the licensee. Finally, so here we've got the Duluth organizers saying in their fairness, balance, and objectivity means that there's a Republican Party and a Democratic Party who virtually control the Senate, therefore no IP party candidate will be included. That's not carrying out their initial responsibility. It is just that delicate balance and those competing interests which have gone out the window in this new scheme, which purports to give Al Franken and Mike McFadden the ability to work out a whole campaign and pick the sites in favorable terms of these three different FCC licensees, WCCO, NPR, and KBJR. Now, in the October 27, 2014 ruling of the Minnesota Supreme Court, refusing to exercise any jurisdiction over the debate issue, Lori Gildea, who's been elected as the Chief Justice at the Minnesota Supreme Court by the voters, claimed that effectively the FCC now runs Minnesota elections. Not the Minnesota legislature, not the First Amendment, not the U.S. Constitution, but now it's the FCC. Thus, she claims the Minnesota Supreme Court and the legislature, by implication, are powerless to keep fairness and balance and to inform the voters. But that is obviously irresponsible by Gildea, and it contests this view in this elections contest. Obviously, barring enforcement of election laws is the worst wrongdoing of all, and barring me from the debates dealt a devastating blow to the IP's chance to survive as a major party in this topsy-turvy year. But so is barring candidates, as I was barred by law from seeking the endorsement of the DFL by saying they can't appeal to the people of Minnesota in the Democratic Party directly without going through gender, race, and sexual practices quotas. Voters and candidates cannot even participate in the caucuses and conventions if they disagree with this corrupt practice of socially engineering democracy, in direct violation of our equal protection laws in the Constitution, 5th and 14th Amendments, barring suspect classifications, and also the 15th and 19th Amendments. These amendments secure the right to vote despite gender or race, but they do not give the right to vote to the descendants of black slaves and do not give the right to vote to women, but instead bar any denial or abridgment of voting rights based on the gender or race of the voter. My rights to vote and participate are bounded because of my white male status and my vociferous disagreement with this corrupt, racist, sexist, and unconstitutional practice which must be abolished. The fact I could not approach and reach these voters to campaign through running for office in the DFL, I could still have run for the Independence Party Senate primary, violated my First Amendment rights, not only of freedom of political expression, but also association. I had every constitutional right to associate with them, except for this quota travesty. The Independence Party endorsement is by just 60 people. There are more people than that in many DFL precincts. And by the Minnesota Constitution, Article 7, elective franchise, it is a constitutional right that I be able to attend the DFL precinct caucus and seek endorsement. But under state law, 202A.16 caucus, who may participate and vote, I cannot attend or campaign if I don't agree that a majority of women have to make all the endorsements. That's DFL Constitution, Article 3, General Rules and Policies, Section 1, Outreach and Inclusion. Quote, they need to select affirmatively such individuals when voting so that such groups being women, minorities, sexual practices, in reasonable proportion to their presence in the state. So in other words, there's 51% of women in the state, although it's not clear which demographic cohort the DFL actually uses, or if they actually use them except when they want to trot them out. Now, in any event, I do not agree with any quotas, because when you throw in racial groups and sexual deviant groups, now straight white males are limited to about 35%. I cannot tolerate this, and I do not believe America does either. Going to this broad DFL base to seek endorsement is a way to campaign, of exercising my political expression and political association, which is now denied to me because of these practices in violation of the 1st, 15th, 19th, 5th, and 14th Amendments. This is an irregularity allowed and condoned by Mark Ritchie and the Attorney General Lori Swanson. Originally, in 2012, Ritchie said he just files the DFL Constitution. He doesn't actually read it. His job duties do not include reading it. But that argument wears thin when it is drawn to his attention, and he still refuses to do anything about it. Combined with the statute limiting voting and participating by me and others like me, this document he files limits my kind, straight white male, to about 35% of the delegates. This clearly abridges my right to vote, and of others to vote for me, and actually denies it because of race and sex and sexual practices. I'm not allowed to attend because I reject the rule. And because I reject the rule, and if I'm an elected delegate, I have to get off the slate. This is intended to, and obviously does, skew decisions. That is the basis of the 19th and 15th Amendments. Not that the voters would be prettier, but that those who had a right to voice their views about decisions the nation would take would be included, not excluded because of suspect classifications like race and gender. It's being used against straight white males and independent candidates and third parties who can offer women and minorities special voting perks and privileges in 2014 and future elections, and needs to be addressed by Congress and the courts. The use of public information, which OSS offered to me in 2010 and 2012, in which Nancy Bream, who still works there, told me OSS had been doing for years, is the third big strategy by Mark Ritchie to take away my ability to get my message out. Under Minnesota Statutes 13.01 of the Minnesota Government Data Practices Act, the Minnesota Legislature, as part of our elections law, has declared that all data collected from Minnesotans is to be public, available in the most convenient form. That would be a disk, not a bunch of paper. And that's according to Minnesota Statutes 13.025 subdivision 4, unless they are classified non-public, as the email addresses submitted by voters voluntarily when they register are nowhere classified as non-public, and therefore they are public information and should be available for use in campaigns, as I have been told they always have been. I have been given 380,000 phone numbers of voters. This was in 2012 for the CD4 campaign. However, I cannot do a mass phone call to them all. I can do a mass email. However, once I tried to use this public information to get out the message that Betty McCollum and her party were actually establishing quotas based on gender, race, and sexual practices, rather than fighting for voting rights for all voters, as she was saying. And that's to say they were actually violating voting rights because the DFL thought they would benefit. Then Mark Ritchie pulled that right that I had, manipulating the arbitrary and capricious capabilities of his office. Betty McCollum had openly called for him to do so. It is a contradiction because Ritchie was charged himself, correctly as it turns out, with taking about 12,000 email addresses and donors, of voters and donors home from the OSS. Now, I got that 12,000 number out of the newspaper. Ritchie handed me about 600 of those email addresses that he took home. And it's obvious from examining them that many of them are included as the same as the ones that are submitted to his office by the same people when they register to vote. So it was okay for him, but it's not okay for me. So, and he used them to raise funds for himself and the DFL. And the legislative auditor said it was all right because those data are public information that anyone can take home. Of course, he works in the office, so it's easier for him to get them. But he did, and this has really hurt my campaign. And it's another irregularity and violation, a serious, deliberate, and material violation of Minnesota election law that undermined my campaign and the IP. So that is for him to pull that right from me, the same one that he has, and try to come up with a kind of a ruling that nobody can use those email addresses. They know they're being sold. I was originally referred to the business office to get them. All right, so I want to discuss now another case, a famous case of Randy Forbes, who currently does serve in the Congress, but in that year, the Supreme Court held that, quote, it is of particular importance that candidates have the opportunity to make their views known so the electorate may intelligently evaluate the candidate's personal qualities and their positions on vital public issues before choosing among them on election day. And I believe that was citing CBS versus the FCC, a 1981 case. So that's what I'm saying. Forbes actually lost that case because he didn't file the equal time provision, and it was there were a lot of complexities in that. But they did make this statement of how fundamentally important it is for the voters to get to hear from the candidates in debates. Now, deliberation on the positions and qualifications of candidates, they went on to say, is integral to our system of government. And electoral speech may have its most profound and widespread impact when it is disseminated through televised debates. The majority of the population cites television as its primary source of election information. Debates are regarded as, quote, the only occasion during a campaign when the attention of a large portion of the American public is focused on the election, as well as the only campaign information format which potentially offers sufficient time to explore issues and policies in depth in a neutral forum, unquote. That's from 1993 from the Congressional Research Office, a publication of campaign debates and presidential general elections. But using voter emails in addition to debates would greatly magnify the debate. That was my plan. And discussion and the uninhibited use of First Amendment rights when choosing the new Congress. And this was stifled by these violations and irregularities and departures from the established Minnesota election laws. In Anderson-Supra, the state imposed the same deadline for filing a petition to get on the ballot for president for the independent candidate John Anderson as it did for the Republicans and Democrats. And even if the facts were different, that the parties had genuinely been withheld, that email addresses had genuinely been withheld from all parties, it would still hit the smaller party and less funded candidates harder and would still be a burden, unreasonable burden. It would have to be justified. So far, there's no justification for that. In Tashkent, where the Democrats took over state government and ruled that independent voters could not vote in Republican primaries, the Supreme Court again ruled the freedom of association protected by those amendments, the First Amendment, includes partisan political organization. Section 9.431 places limits upon the group of registered voters whom the party can invite to participate in the basic function of selecting the party's candidates. The state thus limits the party's associational opportunities at the crucial juncture at which the appeal to common principles may be translated into concerted action, and hence to political power in the community. The fact that the state has the power to regulate the time, place, and manner of elections does not justify without more the abridgment of fundamental rights, such as the right to vote, or as here, the freedom of political association in Tashkent, the burden on this First Amendment. All right, so this kind of ties a lot of things together. Each one of these actions of denying us access to the courts during the election to complain of irregularities or violations. Secondly, the denial of access to the DFL, precinct caucuses, and conventions because of the use of suspect classifications, which violates the U.S. Constitution, and therefore that's an irregularity, and it's also a violation. And third, the exclusion from the debates, and finally the exclusion from public information, which the big parties use, which costs a lot of money. These four things are all things that abridge the fundamental right of association, that you can go in the Independence Party and you can still use these same things that the Democrats and Republicans use. That's an unreasonable burden, and it needs to be justified by the state of Minnesota in allowing this conduct of this election for U.S. Senate and the way that it damaged my ability to get to 5%. Let me go on a bit more. To cite Anderson at page 793, quote, "A burden that falls unequally on new or small political parties or on independent candidates impinges by its very nature on associational choices protected by the First Amendment. It discriminates against those candidates and, of particular importance, against those voters whose political preferences lie outside the existing political parties, or the duopoly." And this comes from another U.S. Supreme Court case, Clements versus Fasching. By limiting the opportunities of independent-minded voters to associate in the electoral arena to enhance their political effectiveness as a group, such restrictions threaten to reduce diversity and competition in the marketplace of ideas. I'm saying, historically, political figures outside the two major parties have been fertile sources of new ideas and new programs. Many of their challenges to the status quo have in time made their way into the political mainstream. In short, the primary values protected by the First Amendment, a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, are served when election campaigns are not monopolized by existing political parties, unquote. That's my complaint. Republicans and Democrats are trying to destroy this party to monopolize the election campaigns. And they did monopolize the election campaigns in the debates. And through the secretary, they are also creating kind of a corrupted monopoly on endorsements. And that is covered by the Constitution, despite what Judge Michael Davis has incorrectly ruled. The primaries, but also the caucuses, when they are part of the integral electoral machinery, as they are here, by getting that party on the ballot and by excluding those who disagree that there should be these identity-based quotas. Even the Republicans are aware of this. Keith Downey mentioned it. So this was all monopolizing the campaigns and the primaries by these parties and their unreasonable burdens and rules. Now, each of the irregularities and violations contained here is a burden on the IP party and me as its Senate candidate. And that burden has destroyed this third party, major party, if this tainted election is held to be valid. It is not valid because it violates the First Amendment, many other constitutional amendments, including Article 7 of the Minnesota Constitution and the equal time requirements of the federal government. As such, I respectfully ask that a panel of judges under Minnesota election law be convened to hear evidence to document all these grounds, and transmit them to the U.S. Senate. And also that the validity of the delisting or decertification of the Independence Party as a major party in Minnesota be rescinded and that status restored. I'm Steve Carlson. I'm fighting for free and fair elections and to maintain the independent voter movement here in Minnesota and across the nation. And thank you for watching.